Is this the way we want to send out a message to society? That's going to come up with top lawyers. But first, the 9 headlines at 9 tonight. Another Kashmiri Pandit murdered in Kashmir, Shopia district in South Kashmir. 45-year-old Sunil Kumar shot by terrorists. Victim's brother injured as security is intensified in the valley. An ITPP bus carrying 37 jawans, 2 policemen plunges into a river in Kashmir. 7 dead, 30 injured in the bus mishap. The Gujarat government is under fire after 11 convicts sentenced to life imprisonment in the Bilkis Bano gangrape and murder case walk free under Gujarat government's remission policy after the Supreme Court allowed them to take a call. 4 arrested for stabbing a man over the Savarkar versus Tipu poster row in Karnataka, Shivamoga. Prohibitory orders are in place. Situation slowly returning to normal. Karnataka minister's audio clip on the government's functioning sparks controversy. Madhuswamy caught on tape saying that the Bommai government is just about managing things till the 2023 assembly polls. Opposition says it's a sign that all is not well in the BJP. Team Nitish Kumar takes over in Bihar. 33 ministers, including Lalu's son Tej Pratap, sworn in. Depleted Congress gets only 2 berths. Rajasthan Congress infighting out in the open over the death of a Jalore Dalit student. Sachin Pilot takes a jibe at the Ashok Gehlot government, saying the Chief Minister must move beyond token action. Milk to get more expensive as Amul and Mother Dairy hike prices by 2 rupees per litre from tomorrow. And FIFA suspends the All India Football Federation over third-party influence and violating FIFA statutes. India cannot host the Under-17 Women's World Cup 2022 as of now. Matter to go to the court tomorrow. But our top story today is coming from the Srinagar Valley, where protests have broken out in several parts over the another killing of a Kashmiri Pandit. Srinagar locals have protested near Lal Chowk's clock tower. Locals have hit the street against the killings of civilians by terrorists over the last several months. Terrorists shot down a Kashmiri Pandit in Chotigam area of South Kashmir's Shopia district this morning, and his brother was injured. Terrorists opened fire on the civilians in an apple orchard. Sunil Bhatt succumbed to the injuries while his brother Pitambar Nath is critically injured and has been shifted to a nearby hospital for treatment. Since the start of the year, at least 25 citizens have been killed in targeted killings. Let's go straight across to our correspondent Sunil Ji Bhatt joins me from Jammu. Sunil, this is the 25th such attack since the start of the year, targeted killings. It seems that people are running out of patience. There has been these protests by Kashmiri Pandit groups for over 3 months now who want to come out of the valley to other parts. What is the government saying?
Absolutely, Rajdeep. There is no end to the targeted killings in the Kashmir Valley. In another incident today, terrorists, assassinated one Kashmiri Pandit named Sunil Kumar Bhatt in South Kashmir, Shopian district. In this terror attack, his brother has also got injured. He is currently getting treatment. He is being treated at Srinagar's Army Hospital. But J&K administration has been saying it time and again that they are going to, send the government employees belonging to the Hindu community to safer areas, but within the valley. So killings have taken place of the Kashmiri Pandit government employees, of Dogra Hindu government employees, and even the Muslims who were seen as, pro-India. This has happened in last 2-3 years because terrorists want to register their presence in the valley. And Rajdeep, today, Sunil Kumar Bhatt, who was shot dead by the terrorists in Shopia, he did not flee, his family did not flee the valley in 1990, even during the peak of terrorism. He was among those handful of Kashmiri Pandits who stayed back. Now, even those Kashmiri Pandits are being targeted.
Is there any specific group claiming responsibility at the moment for these attacks?
Well, Rajdeep, we know that, this is the era of hybrid terrorism in the Kashmir Valley. There is a terror group called Kashmir Freedom Fighters who have taken the responsibility of this terror attack. But we know that these terror, groups named by Kashmir Fight or Freedom Fighters of Kashmir are actually the frontal or terror organizations of Lashkar-e-Toiba and Jaish-e-Mohammed. The investigation is underway, and forensic teams are also on their job. But given the pattern of these targeted killings in last 2 years, it seems that this is also the handiwork of the hybrid terrorists. You know, weapons like pistols may have been used in this terror attack as well. But this killing has once again sent shock waves among the Kashmiri Pandits who are in the valley, or those who have recently fled the valley and are staging protests in Jammu. Now they are adamant, they are saying clearly that they don't want to go back to the valley, serve there, because they are feeling unsafe. Their sense of security has once again been snatched from them.
Sunil Bhatt joining us with those details. Remember, Kashmiri Pandits have been protesting for the last 90 days. Many government employees for more than 90 days wanting to return from the valley. Appreciate you joining us with those details. Let's turn from that story to our top focus today. Think about this. Remember, just about a decade ago, the Nirbhaya gang rape case had shocked and outraged the country. Tough laws were put in place to, in a way, send a strong message to potential rapists. Well, what's happened today? 11 convicts yesterday serving a life imprisonment in the Bilkis Bano gang rape case during the 2002 Gujarat riots were freed from the Godhra sub-jail. This after the Gujarat government panel approved their application for a remission of sentence after the Supreme Court suggested a review. The decision today has been condemned not just by the family of the victim and the opposition, but all those who are saying that we want India to be a safer place for women. Has this case then become a dangerous precedent for the future? It's our other big focus tonight.
All the 11 sentenced to life imprisonment in the Bilkis Bano case walked free incidentally on Independence Day. Their supporters distributed sweets as they came out of the Godhra sub-jail after spending 15 years behind bars. The sentence of the convicts were waived as the Gujarat government approved their remission application. Now, what exactly were they convicted of? 1. Gang rape of then pregnant 21-year-old Bilkis Bano, her mother and 2 other women. 2. The murder of 14 people, including 7 members of Bilkis Bano's family. The victims were fleeing the riots in Radhikapur village when they were ambushed on March 3, 2002. Bilkis Bano's family is shaken. After many requests by India Today, her husband met us away from his workplace and home.
14 लोगों को मारा गया है। उनके बारे में हम रोज़ याद करते हैं, रोज़ उनके लिए दुआ करते हैं। उसमें मेरी 3 साल की बेटी जो है, उनके लिए भी हम उनकी आत्मा को शांति मिले दुआएं करते हैं।
Yaqub says the government never consulted them before taking the decision to waive the convict's sentence, and now he fears for his family's safety.
कुछ तो है, डर है, लेकिन इस तरह का जो मामला आया है तो हमको तो थोड़ा बहुत तो डर ज़्यादा ही है।
Gopal Singh Solanki, who represented the convicts in the court battle, sees nothing wrong in letting off the rape and murder convicts.
ये जो सज़ा माफ़ की गई है उसमें कोई गलत नहीं है। कोई 2 भाई थे, 2 ब्रदर्स, 2 भाई एक साथ में किसी के साथ रेप नहीं कर सकते, एक बात है। दूसरा, फादर एंड सन कांट रेप टुगेदर। और दूसरा, जेल में होने के बाद हर कोई एक्यूज जो तोहमतदार होता है उसके लिए उनकी एंटीसीडेंट देखी जाती है, कैरेक्टर देखा जाता है। और 11 साल में उन्होंने कुछ नहीं किया। अनटूवर्ड इंसिडेंट इनके सामने ऐसी कोई एटीट्यूड भी इनका एंटीसीडेंट ऐसा नहीं था कि उनके अगेंस्ट में जावे, कोई जेल में तूफान किया हो, ऐसा कुछ नहीं हुआ है।
The Gujarat government's decision has sparked a political storm.
कल प्रधानमंत्री जी ने लाल किले की प्राचीर से बड़ी बड़ी बातें की, नारी सुरक्षा, नारी सम्मान, नारी शक्ति। रेप कन्विक्ट्स, बलात्कार के अभियुक्त, उनको आपने रिहा कर दिया कि 14 साल हो गए हैं, इनका कंडक्ट अच्छा है जेल में।
बीजेपी सिर्फ जबानी तौर पर महिलाओं की इज्जत, महिलाओं की स्ट्रेंथनिंग की बात करती है, मगर जहां पर बात आती है मुस्लिम महिलाओं की, आप भूल जाते हैं उनको।
Bilkis Bano's images here are blurred. And there is a reason why. It's because of them. Radhesham Shah, Jaswant Chaturbhai Nai, Keshubhai Vadania, Bakabhai Vadania, Rajibhai Soni, Rameshbhai Chauhan, Shaileshbhai Bhatt, Bipin Chandra Joshi, Govindbhai Nai, Mitesh Bhatt and Pradeep Modia are free today. But do they deserve their freedom? With Saurabh Bhaktania, Bureau Report, India Today.
So has a dangerous precedent now been set by releasing gang rape and murder lifers? Who is to blame here? The government or the supreme judiciary of this country? Has the urgency that was shown after the Nirbhaya case involving such cases completely been lost? Should gang rape convicts be jailed for life, i.e. life? Has injustice at the end of the day been done to Bilkis Bano? That's the story we're going to track. Pinky Anand, Senior Advocate, former Additional Solicitor General of the country, joins me. Siddharth Luthra, Senior Advocate, Supreme Court, also a former ASG. Aman Lekhi, Senior Advocate and another former ASG. And Brinda Grover, Advocate, Supreme Court, Senior Advocate, who's appeared in several such cases. Let's come to you first, Brinda Grover, because in a way, the Gujarat government will say it's the Supreme Court which told us to look and review this case. They have spent 14 years in jail and under the CRPC they are entitled to a review. Therefore, why blame us? If anything, blame our judicial system that allows people to walk free after 14 years.
Rajdeep, the judicial system does not allow anyone to walk out of jail. There is a law which is in Chapter 32 of the Code of Criminal Procedure. There is remission policies which are under the state government. There are advisory boards under state government which determine which of the prisoners will be allowed the largest of remission, and there are a set of criteria, and most remission policies also prescribe which crimes are so heinous that under no circumstances will you be considered eligible for remission. As I understand it, there is a 1992 State of Gujarat policy on remission, which is not available in the public domain. At least I have not been able to read it. The law is that the remission policy at the time of conviction will apply. The 1992 Gujarat state policy, to the best of my knowledge, was scrapped only in 2013. The conviction takes place in the Bombay court. Let us remember, the Supreme Court had actually transferred the trial because it appeared that there was no prospect of a free and fair trial in the state of Gujarat at the time. The conviction takes place in Bombay in 2008, and hence the 1992 policy will apply. What is the state government? Any convict will obviously want to be released. That's besides the point. They go to the court says go to the state of Gujarat. Please remember here, it is not only the state of Gujarat. This case was investigated by the CBI. The law is very clear. Section 435 Code of Criminal Procedure says, if a matter is investigated by the CBI, and I'll read from it, it says the state government will remit or commute a sentence and will not exercise this power except after consultation with the central government. So this decision to release them on remission after 14 years, men who in international law would be arraigned for and they are convicted for crimes against humanity, this is a decision that has been taken by the state of Gujarat after consultation with the central government, which by its policy says rape and gang rape accused are not eligible. This is gang rape and murder.
Okay.
And here I would want to point out, please, this is not that the state's policy towards gang rape has changed or murder lifers has changed. I am not going to decontextualize this. This is signaling a majoritarian state's impunity for certain accused, where the victims are defined and we are defined by certain religious minority victims. This is not a general statement to be made.
Okay,
and the central government is complicit in this decision.
Let's one by one look at the law, because this is a very complicated decision in a way that has been taken that can have huge ramifications. You know, Pinky Anand, The centre, according to Vrinda Grover, was consulted as per the law. What the centre, interestingly, the Home Ministry has laid down that persons convicted for offences who do not qualify for special remission include dowry death, offence of rape and human trafficking. If I am guilty of rape and human trafficking, then I do not get the benefit of remission. This is as per the June 13, 2022 Home Ministry guideline. And yet this has been flouted. The Supreme Court passes the buck onto the states, and the state government's committee is giving remission in a case of a gang rape, of a woman gang rape, and the people convicted for it, and murder, including that of her 3.5-year-old child whose head was banged and was killed in front of her eyes. Is this a fit case for remission, ma'am?
Rajdeep, I don't know what your real question is. It seems to be a dramatization of sorts. But no, if you look at the law,
yes,
and the CRPC and the Supreme Court judgments, right from Ratan Singh onwards, where it is ultimately a decided issue that the courts have nothing to do with remission. It is the state's policy. And where a matter is of Gujarat, it would be decided by the Gujarat state. The Gujarat state decides the matter in accordance with Section 433 and 433A. And that is the decision that they decide to remit after 15 years of sentence based upon the criteria as laid down in their policy. So, I mean, where is the question of dramatizing it to the extent of saying and signifying it as a death signal for some other situations or similar situations? This is case by case. In Radheshyam's case, the Supreme Court asked the Gujarat government to consider it. It was considered. Gujarat government opines itself on remission and releases the convicts. This is the position as it stands.
No,
both on law
that's
as
2
well
points,
as on
ma'am. I just want to ask you 2 points. One, are you saying that the Supreme Court has no overriding powers? If you recall, the Gujarat High Court had rejected the plea of Radheshyam, who wanted remission of sentence, saying we are not going to do it. Then Radheshyam goes to the Supreme Court, and the Supreme Court says we'll allow the Gujarat government to review it. So, could the Supreme Court, ma'am, in your view, have had overriding powers and said, this is a heinous, serious crime, we are not going to allow remission? Could they have said that, yes or no?
I believe not. I believe not. I believe the Supreme Court is bound by its earlier judgments as much as Ratan Singh and the entire series. And as Vrinda rightly said, it is as per the statute as prescribed.
Yes.
So the question is, the statute itself gives the part of the state government in this particular case, which the state government has exercised. So the overriding powers of Supreme Court cannot come in to say, you can't do it. It can tell the government to consider it, can tell the government to review it, but it cannot tell the government you either grant remission or you don't grant remission. It is clearly a matter of state policy until such time as the law stands.
But where does that then leave these guidelines that the Home Ministry has put in place, saying there are certain crimes where you cannot have remission? So within a year of that, you've got this case. Now you're saying it's case by case, but this will be used, ma'am, as a precedent tomorrow by other state governments and, dare I say, by other courts. Doesn't that worry you that even a gang rape and a murder of this heinous kind will now become a precedent?
I'm afraid, Rajdeep, that wouldn't be correct. You can't say it will be a precedent for any state. Every state has its own policies and will exercise them in accordance with their policy. So if a state, for example, has a policy that it will not be granted in case of gang rape, and the policy, incidentally, Rajdeep, as you were quoting, you're talking about the centre's policy of June 2022. That is not the policy in any case that would govern. The policy which clearly the Supreme Court has laid down is the policy that will govern the accused at the time of conviction and not now. So in any case, you can't bring in this centre policy to say that that is what would govern. You are right. We need to have this message constantly that you cannot have any disregard for women. You can't say this will be a precedent for any other state. It is an individual state's policies as they determine it and they exercise it. And the Supreme Court asked the government to consider it. It's not as if it came out of the blue. Right. It is on Radheshyam's petition that this entire matter went to Gujarat for consideration under the 1992 policy, which is a prevalent policy which is relevant.
So you're saying the Supreme Court had no option. In your view, Supreme Court had no option?
Yes.
Interesting. Okay, that's one viewpoint. Siddharth Luthra, you agree with that? Did the Supreme Court make the initial, in a sense, some would say, mistake by virtually saying, look, we believe that under Criminal Procedure Code, they've been in jail for 14 years. Now it's up to the state government. Should the Supreme Court have, in a way, had overriding powers or at least sent out a stronger message that given the nature of the case, you've got to be more careful?
Rajdeep, the issue is this. The Supreme Court relies upon the Constitution Bench decision in Sriharan's case, which lays down the parameters. It takes a certain view and remands it back to Gujarat. At this point, the field is open for Gujarat or any state to act in terms of its prevalent policy. Brinda has said we've not seen the 92 policy. Frankly, neither have I, though it's mentioned in the Supreme Court judgment. The 2014 Gujarat government policy takes a different view, but because the conviction took place prior to that, the prevalent policy will be in vogue. Should the victims have been heard? Yes, obviously, there's no doubt about it. But today, speaking at least for myself, the legal position as it stands is that the Supreme Court judgment remains untrammeled and unchallenged. Had there been a review, or had it been challenged, or had been questioned, things may have been different. But keeping in view the mandate of the Supreme Court 2022, it's a May 22 judgment, the Gujarat government was empowered to act in terms of its 92 policy, whatever it was, and the policy will have to see the light of the day. Of course, it is open to the victims to see whether what the policy is and whether there has been compliance with the policy. Because, as I said, in the 2014 policy, there is a restriction and exercise of power of remission in cases of rape and gang rape and murder. But we don't know the content of the 92 policy. I would assume that it did not exist at that point of time. And therefore, to deal with the other point you said, therefore, the 2022 guidelines of the centre would not apply, keeping in view the mandate of the May 22 Supreme Court decision.
Okay, interesting. But the fact is, Aman Lekhi, and I'll come to you, Vrinda. I know you're itching to get into it, but the fact is that just a minute. I'll come. Aman Lekhi, the fact is the victim was not even, her view is not taken. When this decision is taken by a government committee, the victim's family at least has told us we were not even consulted. Now the gang rapists will go back to the same village where the victim lies. How have you ensured any form of justice? Today, Bilkis Bano could well turn around and say, I haven't got justice. The people who killed my daughter, who killed my family, who gang raped me are coming back to the village.
Let's break it down, Rajdeep, this is important. You're using the expression life imprisonment. Admittedly, life imprisonment in 45 is supposed to mean the duration of a person's life. But section 45 has to be read with another section, that is 433A, which says that after 14 years actual imprisonment, notwithstanding the sentence being of life imprisonment, a party is entitled to apply for remission, which attracts 432. Now, 432 goes to section 57, which helps compute the period of remission. When the matter comes to the Supreme Court, because the law permits remission to be considered, the application is considered by the government of Gujarat. You put this question whether the Supreme Court would override the Gujarat High Court judgment. Now, the Supreme Court can override because it's an appeal. And the reason why the Supreme Court overrode Gujarat High Court judgment, because Gujarat High Court had said that the court appropriate to deal with the matter was Bombay and not Gujarat. What the Supreme Court said was, because the offence is committed in Gujarat, the government which is competent to decide, that is the appropriate government, is the government of Gujarat. Now, the government of Gujarat decides in terms of law which is laid down in 432. You pointed out that the victim is not heard, but insofar as the process is concerned, the process is governed by the procedure in 432, which sets out who is to be heard and how it is to be heard, and that goes with the remission policy.
So does the victim not have to be heard?
The remission policy in issue
Are you
is
telling
the
me,
1992 policy.
Sir, for our viewers, our viewers will want to know,
pardon?
Under the law, victim doesn't have to be heard?
Yes, yes. As far as the remission is concerned, the hearing will entail the judge, the body constituted in terms of the committee under 432, and the facts of the case and the entitlement of the person be considered remission. What's very important is that while 432 entitles the person to apply, it doesn't vest in the person a right to be considered.
Right.
Now, the decision is of the government. There are two aspects to it. One, whether 432 would lie at all, because they're going on saying it's life imprisonment, mainly because it's life imprisonment, because it's not a special category of life imprisonment, which has come later. This is very significant because no one has talked about it. A special category of life imprisonment is where the imprisonment is without remission. Now, that came in 2008 and was affirmed in 2016. The judgment in Bilkis Bano in Bombay High Court came in 2017. The 2017 judgment, notwithstanding the Supreme Court having declared the law that the punishment can be life without remission, chose mainly to uphold the trial court judgment of life simpliciter. Now, life imprisonment simpliciter is different from life imprisonment without remission. Had it been life imprisonment without remission, this order would have been illegal. But because it is life imprisonment simpliciter, remission is permissible. And because remission is permissible, in terms of 432, it has been considered.
Okay, so you're saying...
insofar as the entitlement for consideration is concerned, that is there.
So you're saying the procedure has been followed. You're saying the procedure has been followed.
Is concerned, yes, and so the procedure has been, there's no illegality in the procedure, there's nothing wrong with the Supreme Court judgment, is one aspect of it. The other aspect is when the government decides the matter. The government decides the matter in 432. Now, the decision of the government is not final because the decision of the government is subject to discipline of 14. That is, it has to be reasonable. That is, for all the factors that you said, that look at the nature of the offence, look at the character of the individual, look at the consequences of this particular act, consider also factors releasing this person back into society, and then conclude whether it would be a reasonable exercise of discretion to so release. So it is one thing to say that the decision which has been exercised under 432 is falling foul of the parameters that are relevant. But it's a completely different thing to say that merely because the imprisonment is life imprisonment, there could not have been remission. So we have to first understand what the law is and then impugn it on the basis which law permits. So there's no space for rhetoric or emotions here because you have to go by the law as it stands.
Okay, Vrinda Govar, you want to respond? You cannot go by emotions. Yes, this is a heinous crime.
I'm not going by emotion. Please do not subscribe emotions to me. Everybody else sitting on this panel actually are death penalty votaries. They should be reviewing their emotions, not me. Let me come to the law. The question is, was the victim heard in May 22 by the Supreme Court of India?
One by one.
The order is before us. The victim's counsel, the victim was given no notice. At that stage, the victim was not heard. One, it is not to be heard in the committee. What is the 1992 policy? Why should the 1992 policy not be available on in public domain? Surely there's a Right to Information Act. Section 4 of Right to Information obligates the state to put all such policies on its websites. That 1992 policy seems to be a secret document governing the lives of people. So I would really request the state of Gujarat to make available the 1992 policy so that we are all better informed. Thirdly, yes, I'm very grateful to Mr. Lekhi for pointing out that what is a decision before I come there, it is not only the state of Gujarat which is responsible here. Please look at section 435. Why are we eliding over this section? This crime was investigated by the CBI. Any investigation by the CBI, neither remission nor commutation, strictly reading the law under section 435 CRPC, no remission is possible unless consultation with the central government. So the central government has endorsed, approved, affirmed that this release and remission after 14 years of gang rape and mass murder convicts is okay in public policy. This is not a view only of state of Gujarat. It is confirmed and approved by the central government. That is the law of the land. Now let me come to Article 14. Yes, this decision is capable of being challenged and is subject to judicial review. A decision of April 2022 of the Supreme Court, Ramchandar versus State of Chhattisgarh. I'll read just a short bit. Why? And this is on remission. While a discretion vests with the government to suspend or remit the sentence, the executive power cannot be exercised arbitrarily. The prerogative of the executive is subject to the rule of law and fairness in state action embodied in Article 14 of the Constitution.
You're saying, therefore, this is subject to judicial review. You're saying, therefore...
The court has held that the power of remission cannot be exercised arbitrarily. Remission should be informed, fair, and reasonable. I cannot think of a more discriminatory act by the state and central government than this release.
Therefore, Pinky Anand, do you believe Bilkis Anand, because she can perceive this as unreasonable, unfair to her, has the power of judicial review under Article 14, that even though the procedure seems to have been followed in a sense by the state government, the fact is if she, the victim, feels it's unfair, unreasonable, her rights under Article 14, she can challenge it, judicial review possible or not?
If indeed Article 14 is sustainable, it is not a matter of belief, it is a matter of sustaining such a belief by some cogent situation rather than to make statements. However, if Article 14 is violated at all times, any power exercise is always open to challenge. But a mere belief by itself cannot be the basis. If procedure has been followed, if there is no discrimination, if it is not arbitrary, if it is in accordance with policy, etc., I don't need to say more.
Does the nature of the crime, ma'am, matter? Ma'am, does the nature of the crime matter? The nature, the gravity of the offence?
I'm afraid, Rajdeep, I think this is a matter of state policy which defines where it can intervene and where it can't.
Right.
That itself cannot be the subject matter of any decision. And if you look at Sriharan, if you look at Ratan Singh, if you look at the subsequent judgment of Rajan, each of these judgments very categorically says it is undisputably the state government's prerogative to take a decision regarding remission. So you cannot possibly say or mandate, and the Supreme Court has time and again held, right from Sriharan's case, that you cannot mandate the state government in which manner to actually decide. So I'm afraid that is out of the domain. However, if procedure is not followed and there is discrimination and other issues, possibly that would be the subject matter of judicial.
You know, it's very interesting, Siddharth Rutra. Mohammad Firoz versus State of Madhya Pradesh, 19th April 2022.
I have to leave.
Okay, yes, you told me you had to leave early, but I appreciate that you've joined us. Mohammad Firoz versus State of Madhya Pradesh. Siddharth Rutra, the trial court had awarded a death sentence to Firoz, the accused of a 4-year-old girl. When the matter escalated to the Supreme Court, it confirmed his conviction but commutes the death sentence to life while quoting Oscar Wilde. The only difference between the saint and the sinner is that every saint has a past and every sinner has a future. Is this the Supreme Court in a way trying to ensure some form of restorative justice?
Sorry, I didn't hear the last line.
Is the Supreme Court trying to ensure some kind of a restorative justice, believing that whether it's in the case of Bilkis Bano or whether it's in the case of Mohammad Firoz, someone could, in a sense, reform over 15 years in jail?
I think the focus of your question is perhaps not entirely correct. Today, the Supreme Court has not passed any determination whether the sentence should be reduced or not reduced. All the Supreme Court did was go according to the Supreme Court, and that's the view they took in May 22. Gujarat is the appropriate state, go to Gujarat and Gujarat will determine. So they left it to the government of Gujarat to determine under the policy whether victim should have been heard. Aman has made that point, whether CBI was the appropriate authority or not. But that judgment of the Supreme Court today is finalist unless reversed. This is a decision, an executive decision by the state government. That decision is capable of being impugned if it is arbitrary or otherwise contrary to the policy. So those are separate parameters. Today, we have to be very clear. What are we concerned with? We are concerned with the executive decision, and that is perhaps the subject matter of debate.
That's right.
When the Supreme Court decision came in May 22, from what I understand, there was no review filed. There was no curative filed. If there is no review and no curative, that is under Article 141, the law of the land. And that was very limited. It's a 3-page decision. Perhaps you may have seen it.
No, but
it's only specific to remanding it to the Gujarat government.
That's right. So then let me come to where the crux lies, Aman Lekhi, is the role of the executive. Brinda Gohar says that this has been done in consultation, state and centre. Now, the executive may have other compulsions to release someone, even if the person is someone accused of, is convicted of as heinous a crime as gang rape and murder. A state government may, for political reasons, release someone. We've seen it with Tamil Nadu also in the Rajiv Gandhi assassination case. Therefore, I ask you, should the Supreme Court be re-looking at this or not? Should the Supreme remission, by leaving it to the executive, you're opening it to entirely political considerations?
Rajiv, please understand. I mean, we have to understand this, and I'll deal with this aspect. Sentencing is the judicial function. As far as remission is concerned, remission goes to execution. Execution keeps the sentence intact, and the law is that the execution is by the executive. In the scheme of things, therefore, once a sentence is passed, the ball goes into court of the executive. Has to. That's the scheme of the law. So, as far as remission or commutation is concerned, that is admittedly in law the role of the executive, over which the court has got absolutely no play.
But sir, there will be an element of arbitrariness in the executive.
Discharges this function. Yes, no, just a minute. Now, it cannot be assumed that because the executive is doing it, because it is within the domain of executive so to do. It is arbitrary. However, if in the facts of a particular case it is found that the executive, in discharge of that responsibility which law admittedly vests in it, which is admittedly its responsibility because it's different from the judicial function of sentencing, certain consideration collateral to what is relevant has actually interfered and vitiated it, then that decision will be set aside. This law is settled, so you don't have to revisit anything. The law is in place. If, and as you are saying, if at any point of time it is political consideration which motivates a decision, then a political consideration motivates a decision will make the decision fall foul of law. And if that is so, the decision will be set aside. So the protection of judicial review, you have to see whether the decision has been taken by the right authority and whether the right authority has taken the decision in the right manner.
So you're saying the protection lies with judicial review.
By the right authority, insofar as the procedure.
Protection lies with the power of judicial review.
You don't have to, the law is settled.
Okay, the law is settled. You're saying yes,
Absolutely.
Vrinda.
Because
Vrinda Grover, you want to respond to that because I'll come to you, Siddharth, in a moment because this case has political ramifications. I'm already reading out how political parties are viewing it. You're saying it has to be seen with a majoritarian mindset. There will be others who are saying, look, we've had cases in Kashmir where those who are accused or convicted of rape have got away. So it's a political minefield. Therefore, should such cases be seen in any differently?
Okay, so 2 quick points. I have always been against the death sentence and I have been against remainder of life, natural life, long sentences. What is the argument I'm making here? Why is there a disquiet over this judgment? The law is no longer can be seen as a neutral field over here because the state which is meant to act on behalf of society and in a bipartisan way is no longer conducting itself, and this is manifest in this case. The power of judicial review is a protection still to which this order can be subject. The disquiet is coming from the nature of the crime and the manner in which the state has usually been speaking. We were told that everybody in this country, including the state, believes in death penalty for rapists. Very recently, they were hanged. What is different over here? The difference lies in who the accused are, the nature of the crime and the targeting. Now, if we want to talk about that is where the disquiet lies.
Okay.
And I am saying if the state acts as a majoritarian penal state, we will have to recognize that this is signaling a certain kind of impunity. And if we don't, that is why the conversation about 435, which regretfully nobody is wanting to do here, that the central government has said this. What is the policy of the central government? That gang rapists and mass murderers should be released on bail, should be released on remission. Is that the policy of the central government?
Let me get
That's
both.
not what I heard yesterday.
Let me get both Aman and Siddharth to respond to that because Siddharth, you wanted to jump in first. You go first.
You see, I must clarify one thing, and as Aman said, political considerations. In fact, the Sriharan Constitution Bench judgment even refers to Maruram to say, there were cases where on a chief minister's birthday people were released. So those considerations, extraneous considerations to the principle of 432 to 435 CRPC, which are the provisions relating to remission and the policies of the state, are all if extraneous considerations come in, the decision is vitiated, and once it is liable to be held to be vitiated, once it is challenged in an appropriate court. So if a decision is wrong in letting a person have premature release or remission, that decision is open to challenge. That's one part. However, having said that, and there was one thing which Brinda said earlier, which is interesting, which I must point out, is that the CBI having investigated, the question will arise whether the state was the appropriate government or the CBI was the appropriate government, and I'm not just talking about consultation. So if the centre is the appropriate government, then the judgment of the Supreme Court, which relies upon the Sriharan case, which deals with this, or the issue of, or even the aspect of consultation, because you can't have two appropriate governments. So then the point really will be, is the Supreme Court decision apt to challenge? And if it has not been challenged till now, then we can't say that the subsequent decision taken by the executive can be said to be contrary to the Supreme Court view.
Okay.
And that's what we'll need to test.
Can I get you in, Aman Lekhi, from an average viewer who's watching this program tonight? He will say, after the Nirbhaya case, everyone bayed for blood of the convicts and said death sentence. And eventually they were given death sentence and they said justice for Nirbhaya. Here is another case, gang rape and murder, not just of 1 or 2, 7 people. And the woman murdered. The woman gang raped, 7 people murdered. And here we are saying we must look at remission. Think of it, just a minute, man. The average viewer, Aman Lekhi, will want to know, how does the law operate? Is there an arbitrariness? Are we looking at how the public will respond when we decide on court judgments?
No, first of all, Rajdeep, I think all of us here, Brinda is very agitated and repeatedly using the word majoritarian. That itself shows a preconceived notion as to how this is to be viewed. Whether majoritarian or not, we'll go into the merits of the matter. And you can't start with the assumption of majoritarianism, because then that will vitiate your judgment itself, because it will show you a bias. But that's that apart. As far as 435 is concerned, 435, I mean, I don't agree with Siddharth that the appropriate government is not state of Gujarat, because when 435, read with 432, it's state of Gujarat only, it's correct, there's no other government to the appropriate government. All that 435 says, another thing which Brinda is talking about, consultation. That is, the state government can't do it on its own, it has to consult the central government. Now, when two governments consult doesn't necessarily mean it's a majoritarian decision. It may be a wrong decision, but may not necessarily mean majoritarian decision, because you can't just typecast decision like that.
No, but answer the question. Answer my question. The viewers, answer the viewer's question.
Yes. Yes. Now, as far as this particular question is concerned, a lay person, as far as decisions are concerned, decisions are not going to be taken mainly because there's an opinion one way or the other, because then that will attract a very majoritarian argument which Brinda is condemning. As far as decisions are concerned, the decision will be strictly in accordance with law. That's why I said at the very beginning there are two aspects of it. One is the procedure, and that is a procedural aspect. The other is a substantive aspect. The issue you are raising is whether substantively the decision is wrong. Now, I will not get into majoritarian or otherwise. If the decision is giving a relief to a person not entitled in law, whatever the opinion of the public may be, that decision is wrong. So we have to go by what the decision is. And I firstly feel in this particular case, whether the central government or the state government considered the gravity of the crime, because that's a very material consideration, the purposes will be the key, unless it is considered and factored. If it is considered and factored and for cause remission is granted, then the decision is unexceptionable. But if that is not considered and remission is granted, then the decision will be vitiated. Okay. We are not going to get into majoritarianism, minorities, religion, anything like that, because we can't bring these concepts, everything. The question is, does law permit it? The law will not permit it if the relevant circumstance, the issue which you are pointing out, has been disregarded.
Okay, I will still push for one final time. The distinction between a Nirbhaya and a Bilkis Bano. The distinction between a Nirbhaya and a Bilkis Bano. Final word from you, Vrinda Grover. Is that distinction a valid one or not?
I'm very encouraged by hearing Aman.
And I want to respond to that.
I assume that the doctrine of collective conscience will hopefully one day be purged from our jurisprudence, which has till now actually justified and rationalized death sentence and hanging. Yes, there is a difference between Bilkis Bano and Nirbhaya, and the difference lies in the completely arbitrary, biased, discriminatory approach in which the executive has conducted itself, and therefore, unfortunately, the identities of the women and the identities of the accused can no longer be removed and erased from the story. They are central to the story. But as I would dislike it as a lawyer, I'm not going to be blind to this.
Just a minute.
Okay, yes, Siddharth, you have 30 seconds.
Where is the outrage?
Ma'am, you made your point.
Where is the outrage? Where is the
I just want to...
That's the point. Where is the outrage in this case?
I just want to respond.
Okay.
And this is many rapes and many murders. Nobody asking for death penalty.
If I may...
Good.
Okay. Yes, Siddharth. 30 seconds.
Now, if I just want to clarify, Nirbhaya was a case where the death penalty was given by the trial court, affirmed by the High Court until the Supreme Court. In this case, the courts took a view to give life sentence, and that life sentence has gone up till the Supreme Court. Now the point is, in a life sentence there can be a remission to a lesser sentence, as pointed out by the speakers below me, and after 14 years that policy is to be determined whether it's a case which falls within the policy. In a death penalty case, it is normally reduced to life, sometimes for life till for a certain period.
Right.
Now these are so therefore the fact situation in the two cases was totally distinct. And having been the prosecutor in Nirbhaya, I can tell you that the courts took the collective conscience philosophy or the view that was taken by the Supreme Court was for the first time confirmed and elaborated in the Nirbhaya case. That was not available at the time that the Bilkis Bano case took place, and the period of time therefore is a consideration in terms of the differential sentence that may have been given. Having said that, the fact today is we need to test the decision of the state government, and that is what has to be seen.
Okay, let's test it. Let's see if it goes to judicial review. I've run completely out of time. We've heard each of them. I think our viewers have been enlightened, because at the end of the day, there will be people out there who will say, where is that collective conscience outrage when 11 people are convicted of gang rape are out there in the same village now distributing pedas and sweets? Is this what we want to see? Particularly at a time when we talk about women's empowerment, we talk about Nari Shakti. Is this what we want to see? But let me leave it there. I appreciate all my lawyers joining me there. We stuck to the law, and I'm glad we did. Thank you very much for joining me on the news today. Let's take a break. When we return, we are turning to another big story from Karnataka, where we'll find out the latest in Shimoga, where 4 people were arrested for stabbing a man over the Savarkar versus Tipu poster row. What's the latest from the ground? Coming up on the other side.
I don't read the news. I read between the lines to tell you the true version of events, the true story of our times.
To document grief, the toughest assignment for any journalist to be.
From those who matter,
women politicians going to stick up for each other.
Of those who should matter, I document the truth. I don't distort the truth. I don't glamorize the truth. I don't gloss over the truth.
The ghosts of India's contentious medieval history have come knocking again.
I hustle for the truth, on the ground, in the newsroom, in the studio. I don't try to grab eyeballs.
I inform you to make you see the point.
To the Point with Preeti Chaudhary. At these times, only on India Today. Everyone's busy finding what's trending. You're busy finding out why. India Today, for those who research before reacting. Download the India Today app now.
Welcome back to the other big story, where tensions in Karnataka, Shimoga continue to boil over as a person was stabbed yesterday over a Tipu Savarkar poster war. Police have imposed Section 144 curfew in place and have arrested 4 accused in the case so far. They claim that the accused are not, as of now, being linked to any specific organization. This is only the latest such case of communal tension in Karnataka, which is going to the polls, remember, next year. Section 144 in Shivamogga, and all schools and colleges remain shut. Okay, joining us now is the man on the spot, Alok Kumar, ADGP Law and Order, joins me from Shivamogga. Sir, you're on the spot. Give us a sense of the situation at the moment. Would you say that the situation is fully under control?
Yes, situation in Shivamogga is fully under control. It has been peaceful. So Shivamogga and Bhadravati, both places, we are having proper bandobast arrangements. We have requisitioned the staff from neighboring districts and officers from Bangalore also. They have come down. Around 5 SPs, 15 DSPs, 35 inspectors and more than 1,000 men. They are on the ground. And apart from that, one RF company that is there and 21 platoons of KSRP is also there. And today we had route march in 2 phases in the sensitive areas. One is the part where yesterday the incident had taken place, and another part, another sensitive area of Shivamogga town, we conducted route march. So right now we are keeping close vigil on the situation, and we need to continue this all this arrangement for 2-3 more days. And we have put restrictions on the movement of pillion riders also. There is limited option for pillion riders. So whatever measures could be taken, so section 144 CRPC, that is in place till Thursday. So all these measures we have taken and will ensure that there is no untoward incident.
Are you seeing those any links between what is happening in these parts of Karnataka, both coastal Karnataka and Malnad, because elections in the state are 8 months away, that maybe political parties are using these communal flare-ups, using criminal gangs in a way to divide and rule? Are you seeing the role of political parties in election year?
No, see, I cannot say that these are linked to elections, but anytime, anywhere, election year is very tough year for police in general. So 2023, Karnataka is going to have its legislative assembly elections. So definitely this year is going to have a tough, like police, we have to be on our toes, and there will be a lot of challenging times. So that is there. But I cannot say that these incidents are linked to politics or that political elections. So clearly I cannot say, but in general, whether it is UP, whether it is Bihar, whether it is Gujarat or whether it is Karnataka, election year is always tough for police.
But Mr. Alok Kumar, the question is, why should this suddenly emerge as a poster war? Savarkar versus Tipu results in a sudden flare-up. I ask you therefore, are there some external organizations involved, political organizations behind these flare-ups that are taking place in Karnataka?
No, see, the job of police is to maintain law and order, and we don't look into the background of the people that before taking action. Whoever is at fault, we will take action against those organizations or those people. Day before there was one incident where there also we have taken action, and yesterday whoever has indulged in violence and whoever has violated the existing law, we have taken action against them, and future also we will keep on doing that.
One final question. There is some talk that now the Shivamogga DC and indeed the government in Karnataka is considering banning all such posters, no more posters of Savarkar or Tipu Sultan. What has been decided? Will you allow any public displays of such posters that are leading to these flare-ups?
No, like it is not about Savarkar or Tipu Sultan. Some places there is ban on putting flex board. It has been notified, and 1 or 2 places DC in consultation with SP, he is going to take decision with regard to this, that any type of flex board or such type of poster that should not be displayed. So 1 or 2 sensitive, so district administration, they will take appropriate decision in this regard.
Mr. Alok Kumar, for joining me there in the midst of what's been happening in Shivamogga. You seem to suggest that the situation is slowly coming under control. I appreciate you joining me here on the news today. You have to ask the question, why is it happening in Karnataka as we lead up to an election year? Is there a link between communal flare-ups and the elections? 2 images to leave you with tonight. First, a happy one. The railway is conducting a test run of a 3.5-kilometer long freight train, Super Vasuki, with 295 loaded wagons carrying over 27,000 tons of coal between Korba and Chhattisgarh and Rajnandgaon as part of the Azadi Ka Amrit Mahotsav celebration. So that, in a sense, I am told, is one of the longest ever such journeys that has been undertaken, the Super Vasuki as they are calling it. Let's leave you with our second image of the day, and our second image comes from Kolkata. where Bengal Member of Parliament Mahua Moitra flaunted her football skills during the Trinamool Congress's Khela Hobe Divas sports celebration in Nadia district. Moitra was spotted kicking a football during the celebration. She's been spotted until now mainly in Parliament taking on the government. This time it was a football that she targeted. The Bengali genes seem intact. Thanks for watching. You stay well, stay safe. Good night, Shubhratri, Jai Hind, Namaskar.
Pour les entrepôts de préparation de commandes, donc typiquement un de nos clients est Cdiscount. Si vous passez une commande chez Cdiscount, avant c'est des gens qui dans un entrepôt essayaient de retrouver le téléphone et la coque de téléphone que vous aviez commandé qui pouvaient faire jusqu'à 15 km par jour dans des entrepôts immenses.